Welcome back. We want to dig in now more on the potential imminent indictment of ex-FBI Director James Comey. The Justice Department is preparing to ask the grand jury to indict him over allegations that he lied to Congress in 2020. That's according to sources. Now, they have until Tuesday to get an indictment in, or else that 5-year statute of limitations would run out. So we want to dig into this a little bit more. And joining us now, criminal defense attorney Jeremy Saland, and he used to serve as the assistant district attorney in Manhattan. Thanks for being with us, Jeremy. There's a lot of questions I have, and I hope you'll help me kind of go to law school today and all of our viewers, because I have a lot of legal questions here. Right now, though, ABC News is reporting that federal prosecutors couldn't gather enough evidence to bring criminal charges against Comey after a 2-month-long investigation. And sources told ABC that prosecutors put all of this in writing, that there's no probable cause for an indictment or a conviction, and then they sent it to the newly appointed U.S. Attorney Lindsay Halligan. So my question for you is it common for prosecutors to say they don't have probable cause and then have a U.S. attorney pursue a grand jury indictment anyway?
First of all, it's not common at all to be having these conversations in a public forum. That's number one. Number two, whether it's a governor of a state or a mayor of a city, or in this case, the president of the United States, to be weighing in so passionately to pressure prosecutors on the state or federal level to pursue an indictment. What should be guiding this internally is whether or not there's reasonable cause to believe these particular felonies were committed. And can we ultimately prove this case beyond a reasonable doubt at trial, whether you do or you don't, but can we and affirmatively believe this in good faith at trial and withstand an appeal? We don't have pressure, we don't have politics. This is completely atypical, and frankly, no matter you're red or blue, should frighten you about the term, that lawfare that has been tossed around so frequently and cavalierly.
And I'm going to get to some of those posts that the president has put up on social media and comments he said publicly in just a moment. But I do want to ask you, for those of us who don't work in the legal profession, what exactly does a grand jury indictment look like? What's that process?
So on the federal level, hearsay is allowed, which means that someone could go into that grand jury, like an FBI agent, and say, I witnessed, or I read something, I saw something, I spoke to someone, or firsthand, and this is what I saw. And in this case, it would be alleging that James Comey, said these things. For example, I wasn't involved in the leaking of anything in terms of the FBI and Trump leading to Russia. But we have to establish that he knowingly did so, that it was intention to do so, that he lied and it was material to the proceeding at hand, and he did so under oath, for example. And it's very low standard in a grand jury. It's just basically that there's reasonable cause to believe, not proof beyond a reasonable doubt, that there's a felony, to take it to the next level, not that he's actually guilty. It's a much lower standard.
Okay, so let's get to this now deleted post on Truth Social, where the president seemingly addressed Attorney General Pam Bondi and basically said that he fired the last U.S. attorney because he lied to the media and said there was no case against people like Comey. And then he went on to say that they impeached me twice and indicted me 5 times, and justice must be served now. So here's the big question I have. I've covered a lot of high-profile criminal cases where a change of venue is suddenly requested because of things like excessive publicity, many times on social media. Could that be something that comes up here with the president saying so much about Comey publicly to a very, very, very large audience?
Yes, and I think that's fair, but I'm going to take it a step further. It's not just a change of venue because you're worried about a particular jury pool that you might prejudice, because this is overwhelmingly prejudiced. This is the president of the United States. So whether this is prosecuted, for example, in the Eastern District of Virginia or the District of, the Northern District of Ohio, it doesn't make a difference where this goes, because he stamped this, and he stamped it with such passion and really has biased a potential jury, and it's showing, meaning the president is showing his hand and how he's dictating to prosecutors what should happen. And beyond that, I think there's even a concern for Halligan that she has she has certain principles that and professional responsibilities ethically that she has to abide by. And back to your initial question or point to me about this internal memo, whatever it may say, if she proceeds and forges ahead, knowing that the belief is from the line assistants and those who investigated cannot ultimately prove this beyond a reasonable doubt or potentially secure an indictment if true, that is very concerning. Absolutely, really disturbing. But yes, venue, that's a small piece here. You can't escape the venue on a federal case from the president.
Okay, so let's say that that is true and that memo went to her and she's still pursuing this. What could anyone do about it?
Well, someone can certainly file a complaint against an attorney who's a civil litigation attorney in any matter and can file a complaint against the U.S. attorney. I'm sure this happens with regularity, and that's the nature of the beast. But here, again, as we know, we're speculating because I haven't seen it. But if there's this memo and what this memo says, you should not proceed. And here is why. And again, this is in a public forum. I think it does potentially set you up as Halligan for failure and really egg on your proverbial face in a grand jury, same for the president, but also ethically beyond it. A complaint, a grievance can be made. But it also allows, as a defense attorney, ripe avenues to challenge in a motion to dismiss. So inside that courthouse and then potentially that grievance outside that courthouse should an indictment be secured.
Taking aside that this is about James Comey, who has made political enemies on both sides of the aisle, I think it's fair to say, if you were defending Comey in this, not knowing exactly what the charges are or what they are accusing him of lying of, if you were defending Comey in this, what do you see as weak points in this case?
Words really matter in a perjury type of case. It's one thing to say I was unaware, but what was the question? Or I didn't do something. The question that is asked and the response to those questions matter, because there is a difference, for example, of saying I was not involved in leaking and did not authorize the leaking of information, but I was aware of it, but you didn't ask me if I was aware of it. Or I knew about it and didn't stop it. That's different. Words matter. This is one of those specific situations, unlike an assault, that may be a little more easier to prove. There was an intent in an injury. So I would attack that, but I would also, again, go back to what we keep on going to. The prejudice here and the vindictiveness and the potential prosecutorial misconduct is possibly overwhelming based on what the president shared in that truth to Pam Bondi and his statements since that time. And last but not least, remember, this should be lost on no one. You had an AUSA who decided that this case should not proceed, and Trump removed that person and put in Halligan to do that bidding or his bidding. I think it's right to that line of attack in terms of the rule of law and the interest of justice to ultimately have this dismissed. Again, if it gets
criminal
there.
Defense, if it gets there, yeah, we are waiting for something concrete there to look at. But we want to thank you, criminal defense attorney Jeremy Saland. We thank you so much.
My pleasure.